The erosion of transparency and public freedoms, a deep dive into troubling new municipal bylaws. There's growing concern across Canada regarding recent municipal bylaws that seek to ban public photography and the recording of government meetings, measures that many view as a serious threat to democratic transparency and civil liberties. In particular, one striking case has emerged in Nanaimo, British Columbia, where a newly proposed bylaw attempts to prohibit not only the recording of city council meetings, but also all forms of photography and video recording in public areas, including city parks. This issue, however, is not isolated to Nanaimo. Similar bylaws are quietly emerging in towns and cities across the country, and many citizens, civil rights groups, and legal experts are sounding the alarm over what they perceive as a disturbing trend. Recording city council meetings, a democratic necessity. The first and perhaps most alarming aspect of these new municipal bylaws is the attempt to prohibit citizens from recording city council meetings. This is particularly troubling because these meetings are supposed to be open forums where elected representatives conduct the public's business. When citizens are barred from recording these proceedings, either in video or audio form, it becomes an affront to the very notion of open government and civic accountability. It's important to note that councils already have existing mechanisms in place to hold private meetings when the subject matter is sensitive. These closed-door sessions are typically known as in-camera meetings and are used when discussions involve matters such as personnel issues, legal matters, or other confidential topics. In those cases, the public and media are justifiably excluded, and the sessions are not recorded for the sake of confidentiality. However, when the general workings of the council are being conducted, especially when decisions that affect the public are being debated or voted on, there should be no justification for secrecy. Banning the recording of these public meetings not only undermines transparency, but also prevents citizens from holding their elected officials accountable. Imagine a scenario where Parliament conducted its business entirely behind closed doors and then emerged to announce the passage of laws, without providing any details on the deliberations or who supported or opposed the legislation. Such a situation would rightly be considered outrageous, and yet this is the path some municipal governments appear to be treading. In some cases, public pressure or legal action has caused city councils or school boards to reverse course. For example, in Ontario, a school board initially tried to prevent attendees from recording its public meetings. However, after receiving a legal warning from the Justice Centre for Constitutional Freedoms, JCCF, the board backed down and allowed recordings to proceed. Still, the very fact that such a policy was attempted speaks volumes about the current direction of local governance in Canada. The ban on photography in public parks, a misguided overreach. The second part of the Nanaimo bylaw is even more sweeping and arguably more absurd. A total ban on photography and video recording in public spaces owned by the municipality, including parks, sidewalks, and recreational areas. The rationale given by the city's mayor is that the ban is intended to protect children from being photographed by predators in public spaces. Now, while no one would deny that protecting children is vitally important, this justification misses the mark. A blanket prohibition on all forms of photography is an extreme and ineffective solution. If a person is engaging in suspicious or predatory behavior in a public park, such as persistently taking photos of children, there are already legal tools available to deal with that. Harassment laws, criminal voyeurism statutes, and police intervention can be used to address such cases directly and appropriately. Instead, the Nanaimo bylaw indiscriminately criminalizes all photography and video recording in public parks, meaning that a parent could technically be penalized for filming their own child playing, or a nature enthusiast might be fined for taking a picture of a bird. The overreach is staggering. Moreover, we live in an age where photography and video are not just tools for personal expression or artistic endeavor. They're essential means of documenting public events, protecting legal rights, and participating in civic life. Consider situations where someone witnesses a traffic accident, an instance of police misconduct, or an act of vandalism. Video recordings often become crucial evidence. A total ban on public photography would make such documentation illegal, even if the intent was clearly to protect the public interest. A faulty logic, banning everyone to stop the few. To illustrate the flawed reasoning behind these bans, consider a hypothetical scenario. If some individuals cause fatal car accidents due to impaired driving, should we respond by revoking everyone's driver's licenses? Obviously not. The solution is to hold the guilty parties accountable using the laws we already have. The same principle applies here. The answer to bad behavior in public spaces is not to criminalize everyone's behavior, but to enforce the laws that deal with the actual problems. Public parks, sidewalks, and government buildings are paid for and maintained by the taxpayers. As such, they should be open spaces where the public can gather, document events, and express themselves freely within reason. Yes, there may be times when a photograph unintentionally includes someone else in the background, but this has always been a reality in public spaces. When you step into a public area, you accept that there's a limited expectation of privacy. For example, if someone takes a photo at a public festival or busy shopping mall, it's not unusual for other people to be visible in the background. This is not a privacy violation. It's simply a reflection of the fact that public life is, well, public. Dangerous precedents, and the slippery slope. Perhaps the most worrying aspect of these bans is the precedent they set. If municipal governments can restrict access to public information and limit civil liberties in the name of convenience or vague concerns, what's to stop provincial or even federal governments from following suit? Let's play this out. If enough city councils and school boards decide to prohibit video recordings of their meetings and the public tolerates it, then what's to prevent provincial legislatures from enacting similar restrictions? And if the provinces do it, could the federal government eventually follow their lead? Such a scenario may seem far-fetched now, but precedent matters. Once it becomes normalized for public institutions to conduct business in secret, the slope becomes slippery indeed. We may find ourselves in a situation where crucial government decisions are made without the public ever knowing how or why they were reached. Transparency is not just a bureaucratic nicety, it is the bedrock of democratic accountability. Interestingly, this issue also highlights certain contradictions in existing policies. For example, while parliamentary proceedings in Ottawa are televised and recorded, visitors to the gallery are prohibited from taking photos of the members. While this rule may stem from concerns about disruptions, noise, or privacy, it still reflects a curious inconsistency when it comes to balancing openness and control.